Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today I want to talk to you about whether or not beneficiary designations in estate planning negates a will. Before we get to that though, I want to remind you, if you have questions about this or anything else related to estate planning and you want to talk with us over the phone for free, you can do so by going to estatemeeting.com. Okay. Beneficiary designations in estate planning and wills. This topic today comes from a conversation that I had with a client today that I think is important to sort of reiterate, important to specify so that everybody really understands what's going on, because knowledge is power. All right, so we were talking today and this client's creating an estate plan, doing a will and all the things, and she has the beneficiary designation. Okay, so to back all the way up, what is a beneficiary designation? A beneficiary designation is basically something that you can put on your bank accounts, on your checking accounts, on your savings accounts, on your retirement accounts, on your investment accounts, basically any sort of financial institution account, not pensions usually, but that basically tell the financial institution, when I die, I just want my money to go right here to this person. Beneficiary designation, okay? And you can also do the same thing with real estate. Before you do anything with real estate though, I would really encourage you to talk to somebody, because there can be some sort of unintended consequences if you're giving multiple people a piece of real estate, okay? That is called a transfer on death deed, but it acts just like a beneficiary designation. When you die, if it's your property, the property just goes to the person that you have designated to get it. And we were talking, and my client was wondering sort of out loud, well, hey, if I have all these beneficiary designations in place, then does my will actually do anything? And the answer is no, it really doesn't. Actually, that's not true. That's not all the way true. It does do some things, but it doesn't do what a lot of people think that it will do if you have literally everything set up with beneficiary designations. The will only distributes your property on accounts or with assets that do not have those designations. So if you have something with a beneficiary designation, it is going to take control. It's going to take precedence over the will. It will even take precedence over trust. It will take precedence over anything. If you do not update your beneficiary designation, for example, to your trust after you create your trust, those assets will just go to the people that you have named, okay? That's why it's important to check and just sort of refresh your memory on who your beneficiary designations are every once in a while, just to make sure that you don't have someone on there that you don't want on there anymore. The will still does some functions. It names your personal representative in case it's necessary. Sometimes it's necessary. Let's say you died in a car accident and a lawsuit needs to be brought, then you would want to have a personal representative. Let's say you have bills to pay or you have things that you need to take care of. It's nice to have that will there to just basically outline who's in charge. The will can also take care of your personal property, potentially, even without a probate. And those things are just important to have because it outlines and delineates who's in charge and where you want everything to go. Also, sometimes people forget to update their beneficiary designations. They think they have somebody on the account, but they don't. That account goes into the estate and then it is distributed via your will. Wills also, as a last sort of thought here, they also designate long-term guardians. So if you have children that are minors, you definitely need a will, okay? But if, to answer the original question again, in summary, you have beneficiary designations on all of your accounts, on your real estate, on things like that, then the will won't be doing much for you in terms of asset distribution, which is okay, because that means you don't have to go through probate, you don't have to go through that time, that expense, that frustration for some people. You don't have to do any of that, okay? So that's it. That's the answer to the question. As always, if you like this video, please hit the like button. There's also a little heart emoji. I'd love a heart every once in a while. It feels good. If you have a question or comment, please leave it. I will answer it, I promise you. And if you know someone needs to hear this, that has been wondering about their beneficiary designations for some reason, please share this with them so they can learn about it. And if you have questions about this or anything else related to estate planning, and you want to talk with us over the phone for free, you can do so by going to estatemeeting.com. All right, everybody, boys and girls, ladies and gentlemen, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I'll talk to you again soon. See ya.